Welcome everyone to another breaking Canadian immigration news update. I'm Mark Holthe, Canadian immigration lawyer, coming to you from the broadcast studio of the Canadian Immigration Institute. Now, today's breaking news update is all about express entry. Now, the news itself is a little old, but very few people have been talking about this federal court decision that overturned a refusal of an express entry application because the applicant did not include an exact diploma degree from their educational institution. Now, I want to put out a caveat with this. Yes, the federal court did overturn the officer's refusal. However, you have to pay close attention to the facts and what happened. So let's jump over to the actual court case. You can find a link to it in the description below of this video, and you can go read the decision yourself. But I want to jump in and just pull out the salient information that I think all of you need to know if you're filing your express entry applications, because we all know that R10 requires an officer to refuse if the application isn't complete. Now, what constitutes a complete application? That's at the source of this decision. It came out, the Ontario Federal Court in Toronto, September the 1st, 2021, the Honorable Mr. Justice Lafreniere and the applicant, Dominic Thompson here, challenged in federal court the decision of an officer to refuse their application. And you can see here with the overview that the application was rejected for being incomplete. Okay, most applications, when they're rejected as being incomplete, are returned as being incomplete. But the specific ground here that they've described was for rejection. Was that the proof of the applicant's completed CEC was not provided. Well, what does that mean? That's pretty broad. Let's dive down here and see what the real issue is. If we go down to the factual background, what we know about this is that Mr. Thompson completed his Master of Science in Chemical Engineering from the University of Alberta. So he graduated from my home province here. Way to go, Mr. Thompson. And as we scroll down here, we'll see that the issue he had was with respect to his education. And those of you who have got an ITA and are starting to prepare to file your application, or those who have filed, or those who are even PR, will know that each person has a personalized document checklist. But beside those documents are these little pop-up screens, these little radio buttons that I call them in my express entry step-by-step course. But they have specific information that is kind of dumbed down in layman's terms to help you understand, so that you don't have to be an immigration lawyer to understand how to read the regulations. Well, you'll find out as we go through this in this decision that the Immigration Department and the Department of Justice lawyers feels that, yes, you do have to be able to read the legislation. And, well, let's find out why the federal court didn't buy that argument. You can see that the little radio button here says that you must provide proof that you completed your post-secondary education. Examples of proof of education include a diploma and/or a degree. So pay attention to this, because examples and include suggest that maybe there's something more if an educational diploma or degree is not sufficient. Let's find out. So obviously the applicant requested a formal confirmation from the University of Alberta because he, for whatever reason, didn't have a copy of his degree or diploma. So he obtained a certified information document that contains the following information. You know, it had his name. It certifies that he completed the Faculty of Graduate Studies, Master of Science, the department, and it was awarded June 8th. Everything that you would expect an officer would need to know, right? Well, no, wrong. So IRCC notified the applicant that his PR application was rejected for being incomplete. And this is what was in their letter. Notice the distinction here. Proof of your completed educational credential was not provided with your application, the officer states. And I'll get my mouse on here so you can follow with me. It says that the certificate, diploma, or degree was not provided with your application. This document is required based on the education details you provided in your education profile. Okay, great. The letter of explanation, and he provided a letter of explanation, a detailed one. He provided his transcripts, what they're acknowledging here, as well as that certified document from the university. They say it doesn't overcome the requirement to provide your actual certificate, diploma, or degree. And they basically said they can't consider those things. But they also note, and this is something I want to point out to all of you who have had your applications rejected, it says a full review of your application was not performed. They don't do that. They just pick whatever they can to return it back. And if there are other things, which they indicate here, there may be other elements not identified above, which may also be missing or incomplete. That's the onus is on you. So in this case, Mr. Thompson here received this refusal and he did not accept it. And rightly so. And many of you who receive rejections that are not correct in law, and this is what we're getting at here, there's an element of fairness. There's an element of reasonable expectation that what immigration is telling you in those little radio buttons that are beside your personalized document checklist, if they put it there, then you should be able to rely upon it. Now let's see what Justice Lafreniere had to say about this. So we're going to go into the discussion here. I'm going to scroll down to the analysis. The Department of Justice lawyer for immigration said that basically neither the court, so this judge, nor the respondent, Mr. Thompson, has the jurisdiction to override clear legislative intent, or I should say immigration itself, IRCC. So that's the respondent here. So the court nor IRCC has the jurisdiction to override clear legislative intent. And if you look at this, they identify Section 73(1) of the Act, which defines a Canadian Experience Class application, what's required to meet the language requirements as any secondary school diploma or any post-secondary diploma, certificate, or credential that is issued on the completion of the program. So basically saying, hey, we don't have any room to disregard those regulations. That's the law. Even IRCC is bound. Well, the respondent maintains, as you can see here, that Mr. Thompson, the applicant, didn't submit the required documentation, which would have been the copy of his degree. And there is no authority to accept anything else. And this is the part I love most. The judge says, I disagree. Let's find out why he disagrees. He points back once again to the webpage, right? That's where all your information on immigration is. It's on the website. So if immigration is putting it out there, you should have the right to be able to rely reasonably on that information that's being provided. So let's see. So the judge says the web page, which provides plain language instructions to applicants when they upload their documents, states at the top as follows. You must provide proof that you completed your post-secondary education. Examples, once again, of post-secondary education include a diploma and or degree. And I love the emphasis added. So the judge is telling you what the justice of the federal court is telling you what he is relying upon. And so as we go through this, you'll see he emphasizes once again that when there is the use of word example or include, it suggests that the type of document that can serve as proof is not exhaustive. And then IRCC has intended, if he says, if IRCC intended that it was only going to be limited to a diploma, certificate, or credential, it should have clearly stated that in the instructions. So, and this is one of my favorite parts here. He says, and this is something that I believe, applicants should not need a law degree to understand the requirements to apply for immigration or have to cross-check government guidelines by delving into the complexities of the IRPA and its regulations to ensure consistency. This is something I want to point out because sometimes you will find that the government is slow to update their website and you will have conflicting information. One thing will say one thing and one thing will say another. Based on this decision, I think there's reasonable grounds to challenge a decision if instructions you were relying upon conflict with something else. You should be able to rely upon the ones that are most favorable to you. That's something that I would challenge in federal court, but let's see what else we have here. You can see Justice Lafreniere says the applicant was entitled to rely on the instructions provided online and assume that they were accurate and communicated precisely. He should not be faulted or penalized for relying on imprecise instructions drafted by IRCC itself. And then this is the part that I want all of you to really pay attention to. I'm going to jump back here and I'm going to look in. You need to pay attention to this. This decision doesn't apply across all sets of facts, every person's situation. And sometimes when I see these things being posted, people misinterpret what these cases are really saying. So I should add, and this is Justice Lafreniere says, I should add that the facts in this case are fairly unique. That's code for if your facts line up exactly with these, then you've got a shot. If they don't, if you just didn't include your diploma or degree and included a letter of explanation that said I couldn't get it, I don't think that's going to be enough. It's not. In this case, he highlights that the document the applicant uploaded as proof of Canadian education included all of the information necessary to assess his application. So he included something else, but that something else actually had every detail immigration was looking for. He says, as well articulated by the applicant in his reconsideration request, the document he submitted was his application certifies on its face that he graduated from the U of A, identifies the type of degree, the subject, and the date on which it was awarded. So, couple takeaways. Why is immigration so rigid? They're rigid because they don't want to have to rely upon their officers to have to think any more than they need to. If the instructions that are given to you are clear and concise and they tell you exactly what they want you to provide, then if there's no alternative, an officer can look for that exact thing. And if it's not there, they can either approve or reject and move on. Well, if it's not there, they're going to reject and they can move quickly. Whereas if there are alternatives, then an officer has to think, okay, does it meet this one or does it meet this one? And it slows them down. And in fairness, all of you want your applications processed immediately. You all want them processed in seven weeks, which is one that I just got a thank you note from a client who had their application, their permanent resident application processed in 6 weeks from within Canada. All of you want these wonderfully fast results. It's almost like this badge of honor that, oh, I got mine processed in 7 weeks. Haha, you were 6 months. Well, you must not have put it together as good as me. Right? Am I right? Well, often it's wrong. There are so many factors affecting processing that, yes, a complete, perfect application, which I strive for with every single one of my clients when I do my collaborative reviews, which you can head over to the website, book the consult, and we can do that for you. But individuals need to realize that you have to follow the instructions specifically that immigration provides on their website. Watch carefully. Don't even rely on what I'm telling you today, because what I have not looked at yet is if immigration, following this decision, has gone and amended those instructions to now say explicitly that only diplomas and degrees and certificates are allowed. They're free to do that, which is consistent with the regulations. Whether they do that or not, I guess we'll see. But this is the breaking news update for today. I hope this was helpful to you. Remember, once again, that I have my Express Entry step-by-step course, October the 18th to the 22nd, with a masterclass with me every evening. You can subscribe now, get access to the course videos, prepare, start going through all the training now, and join me in that upcoming live masterclass. And the materials are available for life. Take care, guys. Mark Holthe, Canadian immigration lawyer, ex-immigration officer, and former high school teacher. Saying so long till another news update.